Hi everybody. In the previous session one, discussed in detail what does mean land and land law, what are the basic theories or grounds of property rights, and then we also discussed in detail the forms of ownership type, scope of land rights, up to what extent can enjoy our land rights. Today we discuss session two. Session two, it talks specifically with history of land tenure system in Ethiopia. So in this session we have four main points we discuss in detail. The first is the meaning of tenure system. What does mean tenure system? And secondly, we see tenure system in Ethiopia. So we classified the tenure system in the history of Ethiopian legal system. The first one before the 1974 revolution, and secondly during the Derg regime, and thirdly the current land ownership system. So we see in detail, and I give you a lecture on the three regimes in relation to whether the Ethiopian land resource rights are secure or not. So when I come back with meaning of land tenure, when you say tenure system, it is meaning directly refers this is legal, institutional, and customary rules which determines how owned, acquired, transfer, use, control, administer, manage, and how to uh, enjoy their rights within a society. So land tenure system directly talks about the guarantee of the land resource for the holders of the land resource. So tenure system gives a main idea whether the land rights are secure or not on the hands of the holders or beneficiaries. So this is what does mean land tenure security. So when we determine the land security in the Ethiopian history, when we start from the first one before the 1974 revolution. So in this era or period of time in the northern end part of Ethiopia was administered or managed land resources differently due to the political and other factors. So in the northern and southern part of Ethiopia, land was administered differently. So we see the northern part of Ethiopia first. So in the northern part of Ethiopia, there was a guilt and risk system. So in the northern part of Ethiopia, all lands was owned by the king. The king was the landowner of the time. So in this part of Ethiopia, the king or emperors had owned the land and they had an absolute power to transfer the land for individuals or other selected persons. So at this time, the king had a power to give lands for individual persons, families, or church or other selected persons. So this is what we call land grants. So the holders of the land also we can call landlords. So specific individuals not selected based on family membership, they are selected based on their reasons. They may be church places or other individual persons had acquired lands from the king directly are what we call the system guild system. So in guild system, the king gives lands to individual persons or selected individuals by himself. So the individual persons or other persons who acquired lands from the king directly are Gultanya. So these persons also had a right to transfer to other family members. This is what we call wrist system. So the difference between wrist and gult was the gult holder of the land actually takes the land or holds the land from the king. So these persons are what we call landlords. So the landlords who takes the land from the king had the right to transfer lands to their descendants. So the ascendants had the right to transfer to their own descendants of the right. So in the guild holder of the land, their right was brought, they can sell, they can transfer, they can enjoy, they are collect tax, they can alienate the land by any other means to other persons. But in rest holders, the land grant was basically acquired based on kinship or lineage system or family membership reason. So this is what does mean rest and guilt in the northern part of Ethiopia. So in the rest system, the right was limited to use to control to administer, and this was limited for usufruct right. So at the rest system or the landholders, they cannot transfer the land by means of sale or any other means to another person. So their right was limited to use, to control, or to administer. So this is what does mean the guilt and rest system in the northern part of Ethiopia. When we come to the southern part of Ethiopia, just unlike the northern one, there was the guilt system, but the land grant from the king to some person is, the reason was very different from the first one. At the northern part of Ethiopia, the king or the emperor gives land grants directly by himself for some clergy, soldiers, generals, agent of some specific societies, or the family member of the ruling party or other persons. So this is a direct land grant from the king to specific members of the family or soldiers or some other persons who give service for the king or the emperor. So this is the reason to acquire land grants from the king in the southern part of Ethiopia, unlike the northern one. So the clergy, soldiers, generals, or other persons who acquire land grants from the emperor can use the land, can they rent or collect taxes or other fees as they went from the farmers or the peasants. So they give the land as by means of rent or other mechanisms to cultivate other peasants or farmers, what we call gabbar. So the gabbar at this time had a limited right and accessibility of land resources, unlike the northern one. So rest in the southern part of Ethiopia was limited and not applicable, unlike the first one. But rest in some limited applicability if a guild holder in this system can give for a farmer for a long period of time, it may be what we call restenya. Or if a royal family gives for a peasant to cultivate the land for an indefinite period of time, it may be what we call restenya. So it is accessibility is very limited, and restenya is more or less not workable in the southern part of Ethiopia, unlike the first part of Ethiopia. So guilt and rest in the southern part and in northern part was very different in terms of the acquisition and the power they had exercised. And at the final point, in the southern part of Ethiopia, if the king not need to continue the land grant, they can take it at any time. So the land resource is not secure in the southern part of Ethiopia than the northern one. This is what is the main concept. So when we see the urban land in the southern and northern part of Ethiopia, commonly there was private ownership of individuals of land resource, urban land resource, but the land was owned or possessed by few landlords due to the mechanism of the above guild system. So this is a fact what was for the 1974 revolution at the emperor or king administration time. So this is what looks like land security in this era. The other is during the Derg regime. When we come to the Derg regime, the private ownership of urban land plus the rural land owned by the king was dramatically or absolutely abolished. So there was enacted a proclamation number 31, 1975, and the proclamation, this is rural land proclamation, adopted the public ownership right. And public ownership right directly refers the whole community or the Ethiopian people owned the land commonly or jointly. So the ownership right of the land was on the hand of the people, unlike in the northern and southern parts of Ethiopia before the 1974 revolution. So during the Derg time, the land was owned by the people, and there was the nationalization system. When we see nationalization system is taking land resources without payment for the purpose of public interest. So when we see the difference between nationalization and expropriation, their purpose is similar, but taking of land resource without payment is what we call nationalization, while taking land resource from individuals for public purpose with payment of compensation is what we call expropriation. We use expropriation at this time. So nationalization was applicable at the Derg regime. Plus to that, the peasants was used as they went the farmlands. There was open to farm, cultivate, and do anything in their own plot of land. So the ownership right is on the whole community, but individuals use the right as they need to cultivate or product or invest their power or interest. So peasants or farmers was exercise limited rights at the Derg regime. So the rights, the land rights at this regime also very limited. Individual peasants cannot transfer the land rights by sale, mortgage, lease, or any other transfer is prohibited, except succession is allowed for spouses or minor children if there is adequate reason, even for children attained majority. So without the two grounds, transfer of any land rights was impossible absolutely at this region. So peasants hold or possess usufructuary right only. This is the fact what was in the Derg region. So when we look the urban land at this time, individual persons can hold one individual house for dwelling purpose from the government without fee. So no more can hold or possess or own more houses for the purpose of dwelling or for rent for any other purpose. So there was very limited in the urban areas. So when we look the security of land rights or land resources for peasants at this regime, it was fairer than the first period. This is what looks like at the Derg regime. When we come to the current system, the current land security in Ethiopia, because it depends on the laws and regulations. So we start from the first one, the land policy. We have a land policy, and the land policy specifically gives public ownership right. The ownership right is on the hand of the people, the whole society, or the whole people of Ethiopia. Just like the land policy, the Federal Constitution, Article 40, specifically 40 sub 3, also gives public ownership right. There are so many arguments regarding this issue. Some argue that it is a joint ownership. Some argues it is a state ownership. Some also argues it is a public ownership. The public ownership is on the hand of the people, not on the hand of the state or the hand of the government or the hand of individual persons. Or it is not joint. Compromise with the constitution with land policy, it connotes public ownership. When we come to the rural land, new rural land proclamation 1324-2024 and urban land proclamation 721-2011, it also connotes the same connotation with the FDR constitution and the land policy. So the rural land proclamation specifically gives holding right It not gives ownership right, but specifically gives holding right for farmers or peasants or semi-pastoralists, pastoralists, and other concerned individual persons, and not limited in terms of type. When you compare the two proclamations or laws in line to the land security, the urban is more insecure than the rural one. But generally, in the current system, public ownership type is adopted. So when we compare the current legal system or the current laws with the Derg regime and the first before the 1974 revolution, more or less it is fair and it's justifiable. It gives holding rights for individuals without any discrimination, even in the rural, in the urban areas. But there are so many limitations when we compare with other countries recently. There are more fair and give security for citizens in relation to land rights. So in the modern world, there are countries highly adopted or gives more security than the Ethiopian legal system. But when we compare with the first and the second era, it is more fair and justifiable, and generally, more or less, it, in some extent, secure with its limitations. So this is what I need to say, whether land is secure or not, and what looks like in the three regimes or eras. So for this session, these are the main points we need to discuss in this point. Till the next time, thank you.